Oyez. Anyone having business before the King's Justice, the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all.
Good morning, Your Honor.
Let me just get the screen. Thank you. I'm just having a second getting my screen up. Thank you. We're here.
Your Honor, I'm grateful to the court for starting earlier this morning. I was about to start on the third guide in the factors in Restore. This is a reference to the honor of the Crown. The honor of the Crown directs the Crown to its relationship with the Anishinaabe and to the Anishinaabe perspective. It is the means by which the Crown maintains a mutually respectful relationship. Now, this relationship itself has legal status. It is a recent important development in Aboriginal law, and I'll take you to my compendium, please. Tab 1, Restore, paragraph 70, page 8436.
Thank you.
The Crown's assertion of sovereignty over Aboriginal societies gave rise to a distinctive sui generis legal relationship between the Crown and Aboriginal peoples. That distinctive legal relationship is reflected in treaties and so on. Just some references to the same point in Takuhikin. I won't take you to them, but paragraphs 11, 12, 147, 149, 162, and 203. I would ask you to turn, please, to Takuhikin, which is tab 5 of my compendium, page 8589, paragraph 235. Page 8589, paragraph 235.
I have it. Thank you.
Yeah. Halfway down here, the remedy sought and granted by the Court of Appeal is intended to allow the endeavour of maintaining an Indigenous police force in Majesty, is the town, to regain momentum within a nation-to-nation relationship that is renewed for the future and in accordance with the constitutional principle of reconciliation. So the point here, Your Honour, is that the relationship between the Crown and an Indigenous people, which has legal status, is a nation-to-nation relationship. This is new in Aboriginal law, and it's important with respect to the nature of the remedy for breach of the honour of the Crown. This nation-to-nation aspect is what makes it a public law remedy. Shot both sides and Restall describe the relationship as nation to nation. I won't take you to these paragraphs, but I will in the later section. I'll give them to you now. Shot both sides, paragraphs 73 to 74. It's the first time that the relationship is described as a nation-to-nation one in the context of a declaration for a Section 35 right. In Restall, paragraphs 83, 195, and 282 describe the relationship as nation-to-nation. Paragraphs 103 and 107 describe treaties as nation-to-nation agreements. We've referred to paragraph 180 of Restall. You don't need to go here, please, just for this. There's a description in there of shared goals, expectations, and understandings. And I submit being in a relationship means that one has shared goals, expectations, and understandings. Restall describes this relationship in paragraph 286 with reference to principles of kinship and mutual interdependence. Paragraph 303, Restall says, don't need to go to this. Thank you, Your Honour. After all, historic treaties represent the establishment of, quote, a relationship of trust and mutual assistance. The broad descriptions of the relationship that Restall gives us. These shared goals, expectations, and understandings include the Anishinaabe values or principles of respect, responsibility, reciprocity, and renewal. I'd like to make, Your Honour, some general responding submissions about the ascertainment by the Crown of Anishinaabe principles. My friend for the Huron interveners said it was absurd of Ontario to suggest that it has expertise in Anishinaabe principles. Ontario does not suggest it has any particular expertise. Ontario accepts that it does not have the same depth or breadth of knowledge that the Crown had in 1850. Ontario does suggest that the Crown can learn. The Crown has learnt through the engagement process directed by the Supreme Court. Yes, it makes sense for Crown representatives to have a deep knowledge of Anishinaabe protocols and legal principles. Yes, it is ideal if Crown representatives are well versed in Anishinaabe Moa. Ontario submits that the Crown is, as a result of that engagement process, with respect, better placed than a court on a review. The engagement process provides the Crown an opportunity to share its understanding of relevant Anishinaabe values and to give the Crown's understanding of how these principles might apply to the decision. Anishinaabe can respond, correct, and add. Wish. To return back to Restore then, Your Honour. Paragraph 197, and I'd ask you to turn this up, please.
Just on that last point, I'm sure this is spectacularly obvious to those people who work for large institutions, but when you say the Crown can learn, the Crown can or has learned, the Crown, whatever you say about the Crown, in these situations, the Crown is represented by individuals, by people. And in this case, for instance, we're on our third generation of lawyers from Ontario. And it's not immediately obvious that there is what we call corporate memory. So I'll just leave you with that. It's not much of a quibble, but the Crown learning is, for me, too easy a way to say how the individuals involved at the table, whatever level of representative they might have been, are engaging with principles. But maybe you have a comment on the Crown, what it means when you say the Crown and talking about learning.
Well, I don't have a comment or response. I think the court's comment is fair, and I could only say that the Crown takes its obligation to understand the Anishinaabe perspective seriously. There is a lot for individuals to learn, and that might require some institutional adjustment.
You have asked me to turn something up.
Yes, Your Honour. Paragraph 197 of Restore, page 8444.
You.
The Crown must exercise its discretion, including its discretion as to how often it turns its mind to increasing the annuity, diligently, honourably, liberally, and justly, while engaging in an ongoing relationship with the Anishinaabe based on the values of respect, responsibility, reciprocity, and renewal. The other parts are bolded for different reference. Turn back, though, to page 8435, please, which is paragraph 18. the Anishinaabes' system of governance and their relationship with the Crown have always been based on the values of respect, responsibility, reciprocity, and renewal. It's important to note the words based on, Your Honour. These principles or values do not govern the relationship. Bristol does not say that. Bristol does not say that these principles or values require or ensure a particular result. Nor does Bristol say that the compensation amount must be consistent with these principles or values. Now, my friend for the plaintiff said that Ontario's explanation at paragraph 1.
Perhaps we just need to go back to that. What is the point you are making?
The expression, the Crown has an obligation to understand the Anishinaabe perspective. It's an obligation under the honour of the Crown. The Anishinaabe perspective includes these principles or values. The court has said that the relationship, which is what the honour of the Crown is directed at, is guided by, is based on these values. The remedy of a compensation amount is directed to the repair of the relationship. It does not require, an honourable compensation amount does not require consistency with these principles. It requires repair of the relationship, and the relationship is based on these principles. It's a subtle point, but it relates to the role of the principles in measuring the honourableness of the amount.
Perhaps it's a bit too subtle for me. Partly because you, earlier in this submission, you referenced the shared aims, goals, and expectations. And if one party comes to the treaty negotiation with a certain set of expectations, or let's say this, the Crown, as you say, and has been found, came to the treaty fire with a significant knowledge base in Anishinaabe law, protocols, values, principles, and therefore would be taken to know the aims, goals, and expectations of their treaty partner. And if those expectations are based on respect, responsibility, renewal, and reciprocity, do you say it's honorable to say, well, those aren't ours? The Supreme Court doesn't tell us we have to be consistent with those, even though we acknowledge that that would have been the aim, goal, and expectation of the party, of the treaty partner.
So firstly, there's an obligation to explain. So when the court says, when the Crown says the law is not this, it does so, I hope, respectfully. The second point about consistency is yes, the Crown must explain in relation to those principles through the engagement process, but the Crown does not have to, and the court should not, determine the honourableness by applying a principle to the amount and saying this amount is consistent with this principle. And so
Let me just see if I've got that. So that the test of honorableness, you say, is not measured against meeting these principles? Or is it just the test of honorableness in setting the amount?
Well, not honorableness in general, because I don't want to speak for all relations, but in setting this amount here, because I just want to focus on the case. Your Honour used the expression meeting the principles. Well, that's not something that's in Restore. So I don't want to adopt that, Your Honour. It might be helpful if I turn to sessions of my friends to explain what they say should happen in relation to the principles, and then that might give you a sense of
where you're going,
where I'm going. So my friends say that a Crown decision inconsistent with such principles would be a breach of a constitutional treaty right. And that's not what the Supreme Court said or intended. A determination of breach requires a trial and an action for a declaration of breach, not a judicial review. The reference for that, Your Honour, is the Tunaha case, KTNUNAXA, at paragraph 84. Oh, don't need to bring that up. A determination of breach of a constitutional treaty right requires a justified infringement analysis. I note that the Supreme Court called them principles and also values. These notions are not immutable or fixed in scope, as is a treaty right. They're highly context dependent and can be balanced against other principles. They are guidelines for decision. Calling them, as my friend for the Huron interveners does, fundamental principles, highlights their importance, but does not change their nature. It does not change a deferential review to a correctness review. The court's honour does not require that the Crown's decision here, be correct on the terms of these Anishinaabe principles or values.
The Crown's honor does not require this?
Yes. When I speak of the honour, I speak of the Crown's honour.
Thank you.
Crown's honour does not require consistency with these. It does not require that Crown decision be correct on the terms of these Anishinaabe principles or values.
Be correct on the terms. What
Yes.
does that mean?
Well, the court, the Crown and the court should not take a principle, one principle, and apply it to the amount. And I submit respectfully that courts should take care in describing the application of Anishinaabe principles to particular facts. As my friend noted, these principles are not bounded conceptions of language, but are relational. My friend further said, each principle is linked to the others in a sort of web. A correctness review would give a weight and fixity to the principles. According to Eurocentric notions, this is my submission, of law and legality that could do more long-term harm. This does not result in the improper privileging of Eurocentric notions, because the honour of the Crown requires the Crown to engage and to consider the Anishinaabe perspective. I was mentioning my friend for the plaintiffs misstating Ontario's explanation, paragraph 1, saying that Ontario said the amount had to be consistent with Anishinaabe values, and paragraph 1 says engaging in an ongoing relationship based on Anishinaabe values. I'll take you back, though, Your Honour, please, to paragraph 180 of Restore and ask you to turn it up. It's at page 8442. Here, halfway down, the court's quoting the Court of Appeal. They added, this exercise should be led by the treaty parties' shared goals, expectations and understandings, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal identified by the trial judge. So I want to emphasize there the words led by, not governed by.
I struggle with these fine distinctions you make.
I want to refer, Your Honour, back to the correctness submission, correctness standard review of the plaintiffs, and whether the court is to take an Anishinaabe principle in the abstract and consider the amount directly against one of it and say, well, it does not meet one of it, or two or more, when the court has said that these should lead the parties. Does not govern the amount, as my friends have submitted.
Well, you're now switching lanes. You said these words from paragraph 180 should be led by, and then you continued, does not say should be governed by. And then your last sentence, I believe, was the amount is not governed by. But this paragraph refers to the parties' conduct in the engagement process.
Yes.
Right? The parties should be led by shared the exercise should be led by the parties' shared goals, expectations, and amount. And then you somehow get to the point you're making that the amount need not be governed by these things.
Yes, and here, you're correct, Your Honour. Here in this paragraph, the court is referring to the relationship and not to the amount. Mm-hmm. That's a step that I'm making.
All right.
But in response to my friend's submissions. My friends said that the Crown must decide an amount in accordance with these principles. Those are words my friends used.
And these are, you're referring to the Huron submissions?
Yes,
Thank you.
but Bristol does not say in accordance with these principles. I'll refer Your Honour, please, to paragraph 263 of Restore. Which is page 8449. And this is a description of the breach. The court says, this is 6 lines down, in doing so, they, the Crowns, agreed that they have failed to uphold both the honour of the Crown and the principles of respect, responsibility, reciprocity, and renewal that underpinned the Anishinabe's perspective on the treaty relationship with the Crown. So here the court is describing the breach in terms of the Anishinabe's perspective on the treaty relationship, rather than directly in relation to these principles.
I'm just reading from the transcripts, see if I've got this right. Court is describing a breach in terms of the Anishinaabe perspective on the treaty relationship, rather than directly in relation to these principles.
Yes.
I'm grasping.
The role of these principles is to inform the Crown of the Anishinaabe perspective on the decision that the Crown has an obligation to make.
Okay.
That is their role. Their role is not to, in and of themselves, limit the Crown, or direct the amount the Crown decides. They do not, by themselves, set the standard to judge whether the Crown has honourably implemented the augmentation clause.
Okay. And that's where we got to before, that you say the values and principles, the Anishinaabe values and principles, are not the metric against which the Crown's honorableness should be tested.
Not by themselves.
Not by themselves. Okay.
And I don't want to downplay them, Your Honour. They
Yes.
restore paragraph 17,
Yes.
describes them as law. They're part of Canadian law. I just want to explain the role they play in the Crown's determination of the amount. And in terms of remedy, which is what we're doing here, is directed by the Supreme Court, I ask you to refer to tab 5 of my compendium, which is Takuikan.
Okay.
Tab 5, page 8579, paragraph 11. Given that. The wrong paragraph. Sorry, Your Honor. I have the wrong paragraph, Your Honor. I'll give you the reference later and you can turn to it later, but I'll read the quotation, which is from Takuikan, just not from paragraph 11. Given that the exercise is concerned with the relationship between the Crown and Indigenous peoples, it is important to be sensitive to Indigenous perspectives on the manner in which the relationship can be restored. Sorry, Your Honor, it's 211, not 11.
And that is, I'll just find it. Got it. Thank you.
So here the court is saying that in determining a remedy, it's important to be sensitive to the Indigenous perspective. And elsewhere, the court has described the Anishinaabe perspective as being these four principles. So if we tie the two together and said determining a remedy, it's important to be sensitive to these four principles. Again,
The remedy should be?
yes. So not judged by the standard of each principle in the abstract.
Not judged, being the amount should
Yes,
not be judged.
or any remedy, but the amount in this case.
And what about the engagement process?
Your Honour, one of my colleagues is going to provide submissions about the engagement process, and I'll leave that to her.
Thank you.
On to remedy and restore. The court held that the Crown had breached both the treaty and its honour. The court was clear that it was determining one remedy for both. In Shot Both Sides, Restore and Takuikan, the court set out the principles for remedy. And the reasons of Justice Obonsuin and Shot Both Sides were the first, and they set the direction. I ask you to turn, please, to tab 6, of my oral compendium, page 8592, paragraph 73, tab 6, 8592. Now, it was not new to understand reconciliation as a process, but Justice Obonsuin explained that remedies for historical breach are part of an ongoing reconciliation process. And you can see this in these paragraphs. If you turn, Your Honour, to paragraph 73, in reference to declaratory relief, on the right, on 4 lines down, can help to uphold the honour of the Crown, guide the parties in the reconciliation process mandated by section 35(1). Paragraph 74 6 lines down, declaratory relief is not meant to represent the end of the reconciliation process for the Crown's breach. Paragraph 79. The declaration sets out the Crown's conduct and guides the parties towards the reconciliation process. The rights are constitutionally recognised. Declaratory relief of this nature aligns with and advances the constitutional imperative of reconciliation. So, a remedy for historical breach is part of an ongoing process. And then I'll mention briefly some principles arising from Takuikan, but my friends have covered them, and I don't need to go into them in much detail. You've heard, and I agree, Your Honour, that reconciliatory justice is a public law concept. It permits and requires creativity and flexibility in remedies, which are highly contextual. And that is, Your Honour, because a remedy for breach of the Crown's honour is directed at the repair of the relationship. One must be flexible and creative when repairing a relationship. The remedy, Your Honour, depends on the obligation breached.
Well, it depends on many things.
Yes, yes. One of the factors. My friends for the plaintiffs referred to paragraph 148. You don't need to turn that up. That paragraph says that the purpose of the remedy transcends the corrective justice at the heart of private law. Now, I don't submit that
Paragraph 148 of Restul.
No, sorry, Your Honour. Takuikan.
Oh, thank you.
It's at page 8581.
Thank you.
I don't submit that reconciliatory justice excludes corrective justice. I submit that reconciliatory justice is not always corrective justice plus something extra. If it were, then one could only ever determine reconciliatory justice by adding past losses first. In Takuikan, the court said you don't have to do that, not expressly. But in that case, it did not send the matter back for trial as to damages. And in doing so, in not doing so, but in setting a reconciliatory amount, the court indicated that it did not need to know what corrective justice required in that case. It did rely on the evidence adduced for the purpose of a corrective justice calculation in the specific facts of that case, but it did not first undertake a corrective justice calculation.
Or were they saying they didn't need to know with exactness or precision? Because, I mean, they had numbers
Yes.
for them.
Well, they had numbers and they used them to guide the remedy for repair of the relationship. They did indicate and state that if a damages assessment were required, it would need to be sent back. A corrective justice assessment were required, it would need to be sent back. So they had some numbers, and there's perhaps a question about the role of evidence in these cases in the future. But in Takuikan, the court didn't feel it needed to get into that question.
And as you have said, context is everything.
Yes.
We're talking about a couple $100,000.
It was, in that case, 1.5 million, which is,
Oh, I'm sorry. And 1.5 was what the nation said they were out
yes.
in policing?
Yes, half, almost each from Quebec and Canada.
Okay, thank you. In any event, context is
It's highly contextual.
significant.
It's still within Takuikan, Your Honour. Please turn to paragraph 210, which is page 8584 of my compendium.
Okay.
The purpose of this exercise is not to remedy the consequences of a civil fault, but rather to impose a measure that restores balance to the relationship between the parties and thus places them back on the path to reconciliation. And across the page to 216, please. Quebec did not deal with it, that's Takuikan, on an equal footing and did not display the spirit of mutual cooperation and respect referred to by the minister and the federal policy. This is also part of the damage caused to the relationship, which must now be repaired. So reconciliatory justice, Your Honour, seeks to restore balance to the relationship and to repair damage to the relationship. And we can then see restore in the context of shot both sides, talking about an ongoing process of reconciliation in Takuikan afterwards, talking about reconciliatory justice aimed at repair of the relationship. But Restore is actually quite explicit about the purposes for which it is directing a remedy. I will give you the paragraphs, but not take you to them.
Question that has been vexing me for some time is, in a world where the goal is to restore the relationship, and relationships are necessarily between multiple parties or at least two parties, can one party ever say the relationship is restored, or this serves to restore the relationship if the other party disagrees? Like, how is that an argument in the arsenal to say, we think that this moves us along the path towards a restored relationship, and the other party says, we disagree?
It is the difficult question, Your Honour. We're here as litigants before the court, and one of the litigants says the relationship is not restored, repaired, and the other one says it is. And the court can look and say, well, if the relationship were restored, why is one party here saying it's not? But
Or is the party only saying this step you have taken is not?
right, so it's a step on the path to reconciliation. The goal is to restore the relationship, is to repair the relationship. But the legal standard is to restore the honor of the crown. So the question is, does the remedy, or in this case, the amount, restore the crown's honor? Now, ultimately, it's directed to the relationship, and it's very hard to nail down whether that has occurred, but there has to be a legal standard, and that is the restoration of the honor of the crown. But sorry, but you're right, that's the difficult part of this process.
And just to provide another avenue of asking that question, when one assesses the honor of the crown, in whose eyes is it being assessed? The party who has the power of the crown, or the party who is at the receiving end of an exercise of that power? So does the exercise of the crown power, does the party who exercises the crown power say, well, in our perspective, this is an honorable exercise? I think the obvious answer is it's the court.
It is the court
Who says that, but I am hearing from the crown, this is honorable, absolutely.
Yes, so the theoretical basis is that it is the crown's honor. And the crown wishes to maintain its honor. Sometimes it doesn't. Has that pointed out to it, tries to fix it, and then we end up in front of the court, and the court says, you have or have not met the legal standard. And we are at the beginning of this jurisprudence, Your Honour, and there will perhaps be more guides as we come along, and that's why we're grateful to the court for taking this case without as much guidance as we might wish for from the Supreme Court. But that's just where we find ourselves. It's inherent in the problem of bringing a nation-to-nation relationship before a court, which is why courts say it's better not before them. So that's an unsatisfactory response. I'm sorry, Your Honour, but we're grateful to the court.
Thank you.
I should add, Your Honour, that a technical answer is one which my colleague will give, which is the standard of review in the court's review of a Crown decision. And the need for deference to the Crown in the in this case.
Thank you.
So references to restore and the purpose of the remedy: 277, 278, 301, 302, 303, 305. The primary means of remedying a breach of the honour of the Crown is a declaration. This tells the Crown what its obligations are. The Crown can then be expected to comply with those obligations. The Crown, under the honour of the Crown, must implement its treaty obligation as described in a declaration. In this case, the treaty obligation is to exercise discretion, whether to augment annuities, and if so, by how much. And we know that the Crown must do so in a purposive and diligent manner. And this is, Your Honour, is a really exciting part as a development in the jurisprudence. This honourable obligation is ongoing. In other words, there is no time like the present. And I'll ask you to turn up, please. Shop both sides, tab 6. Paragraph 76.
Thank you.
Treaty promises were intended to be honoured so long as the sun rises and river flows. Just the first sentence. Put another way, the honour of the Crown with respect to treaty promises does not dissipate over time. The obligation to implement does not dissipate over time. Here, the Crown must, under the treaty, do now what it always had an obligation to do. Must consider whether to augment, and if so, then to pay. Must then pay. It must do so in respect of the entire time in which it did not meet that obligation, because that obligation is outstanding now. It must do so, as Restall says, retrospectively, and quote, with respect to the past. And it must implement now regarding the past. These are quotes from Restall, which I'll take you to in a second. But I submit this makes the compensation payment an exercise of discretion under the treaty right. It is an annuity payment, not a damages payment. It is the implementation of the treaty right. Your Honour, I'm going to ask the court's indulgence to go through a run of Restall quotations.
I just have a question. Do you say that by sending the matter to the Crown to exercise its discretion, you say that the Supreme Court was saying there are no damages for breach of the obligation to implement the treaty?
Well, it said there's compensation. It said the Crown has to pay compensation. That's what it directed the Crown to do.
But you're making a point here.
Yes. I have to check.
The compensation is the exercise of the discretion.
Yes, so it does use the word damages at different, I think at different points, but it doesn't direct the Crown to pay damages or to consider damages.
I actually wasn't, that wasn't my point about directing the Crown. Was it saying the remedy is the declaration? The remedy available is the declaration.
And the direction
And the direction. Not damages for breach of the duty to diligently implement.
well,
It's not a law school test.
no. I mean, it did say it's one and not the other, but these paragraphs I'm going to take you through show it saying the Crown's obligation is to diligently implement now, and then it directs that the Crown diligently implements now. It says this is what the law requires, diligent implementation now, which is the exercise of discretion. And then it says we're going to direct you to do what the law requires because you've been so egregious in breach for so long and your honour is so depleted. So paragraphs 10 to 11. Starting page 8432. Paragraph 10. Yeah, next page, maybe. Oh, no. Here we go. 6 lines. The next page. Second page over, please. 8432. 7 lines down. Thus, in my view, the Crown must increase the annuity under the Robinson treaties beyond $4 per person retrospectively, 1875 to the present. It's the court's italics, must increase the annuity retrospectively. And then paragraph 11. Eight lines down, seven lines down. As I have indicated, the Crown must exercise its discretion and increase the annuities with respect to the past. Over to paragraph 13. Five lines down. In the reasons that follow, it should be clear that Ontario and Canada must act now, court's italics, to respect their treaty promises to the Anishinaabe. Paragraph 248 at page 8445. 248 shows that remedying past breaches is part of present diligent implementation. Remedying past breaches is part of present diligent implementation. So there's a heading here, paragraph 248. The heading says the Crown has a duty to diligently implement the augmentation promise. And under that heading, the court says, all parties before this court agree that the Crown has an obligation to diligently fulfill or implement the augmentation clause. They diverge on precisely what this duty requires of the Crown in practice, i.e., what the duty to diligently implement requires the Crown to do now, including how the past breaches of this obligation should be remedied.
That's where the parties diverge.
Well, they diverge on precisely what it requires, including how. Yes, well, they diverge, but then the court then determined. We'll go on to see what it requires. So paragraph 253 to 254. These paragraphs, Your Honour, say that the present obligation of diligent implementation is the same as the past obligation of diligent implementation. The present obligation also requires the Crown to remedy past failure to implement diligently. In Restore, present diligent implementation requires this specific remedy for past failure. So if you turn to paragraph 253, please.
Yes, I have it.
I conclude, 3 lines down on the right, I conclude that the Crown is required, and indeed was always required, to act in an honourable and timely way to pursue the purpose behind the treaty promise. As I explain when addressing remedies in the next section, this, i.e. acting in a timely way, this requires the Crown to pay an amount subject to review by the courts to compensate the superior plaintiffs for its past breach of the augmentation clause, which in this case is a breach of both the duty of diligent implementation and of the duty itself. And then the next 254, the duty of diligent implementation holds the Crown responsible for making good on its treaty promises. So diligent implementation requires the Crown to do now what it hasn't done in the past. Then to 257. Elaborating on the second requirement, the majority explained that although the law assumes that the Crown always intends to fulfill its solemn promises, including constitutional obligations, the Crown's obligations go further. If the honour of the Crown is pledged to the fulfilment of its obligations, it follows then that the honour of the Crown requires the Crown to endeavour to ensure its obligations are fulfilled with due diligence. And 258 at the start just notes the same point. The Crown's duty notes that the Crown has a duty to ensure that its obligations are fulfilled. So, Your Honour, Crown's present duty to ensure that the Crown fulfills its obligations that existed in the past. Paragraph 281. A couple more after this. 281. On page 8456.
I have it, thank you.
So 4 lines down. Such a declaration will be a definitive statement of rights that the treaty partners can rely on in negotiations to determine how the augmentation clause must be honourably implemented regarding both the past and the future. So honourable implementation in the present regarding past breaches. And then 287, which is on page 8459. And the last 4 lines of 287. I would therefore provide additional direction to the Crown regarding the superior plaintiffs to ensure that it exercises its discretion under the augmentation clause. And the bottom, 4 lines from the bottom, it exercises its discretion under the augmentation clause in a timely and honourable manner regarding past breaches. So the purpose, Your Honour, of the direction for 6 months engagement and then a Crown determination, if necessary, is to ensure that the Crown diligently implements its long-standing promise. The last of this run of quotations is paragraph 292 on page 8461. However, now that this court has finally determined the Crown's obligations under the augmentation clause and given Ontario's position before this court that we are listening and you are going to tell us how to approach this, it can be expected that the Crown will diligently honour its long-standing treaty promise to the Anishinaabe. In my view, given the nature of the treaty promise at issue, the Crown must be afforded a circumscribed window within which to exercise its discretion, either through honourable negotiation or by determination of the Crown if necessary. So the discretion the court is referring to is the exercise of discretion under the treaty with respect to the past. The court is saying to the Crown, you haven't done it, you need to do it now. As I said before, that is the Crown's obligation under the law, and the court is directing the Crown to do it because of how depleted the Crown's honour is in this matter. Ordinarily, a declaration would be enough, but not here. And please note, Your Honour, that I'm not going to ask you to turn it up, paragraph 283 of Restore. But I will ask you to turn up, please, page 287.
Yes.
At the bottom of the paragraph, I would therefore provide additional direction to the Crown regarding the superior plaintiffs to ensure that it exercises its discretion under the augmentation clause in a timely and honourable manner regarding past breaches. That's what the declaration is doing, Your Honour, ensuring that the Crown diligently implement, as it has always had an obligation to do. And then the Crown directed that this honourable implementation be determined taking into account 5 factors. Those are the 5 factors in paragraphs 271 and 309. The court describes this decision as polycentric. And I refer you, Your Honour, to paragraphs 294 and 308. I'll ask you to turn them up, please. Paragraph 294 is at 8462.
Thank you. I've got it.
The amount by which the Crown might increase the annuity is a polycentric and discretionary determination that will inevitably reflect many social, economic, and policy considerations that may change over time, affecting the frequency and nature of net revenue and annuity calculations. Determining the amount of compensation owed for the past will involve similar considerations. So it is, the compensation decision is the same type of decision as a regular augmentation decision.
As in polycentric and discretionary.
Yes. And the same point is made, Your Honour, at paragraph 308. I don't need to take you to it. The compensation decision, Your Honour, is not about adding up payments that might have occurred in the past, could have occurred in the past, would have, or should have. The court did not use those expressions.
I worry you're doing your best to destroy a straw house that you have built yourself. I don't take the plaintiff's position that the exercise is to add up the numbers for a decision. My understanding, I certainly hope I'm not wrong, was to make an assessment, and the assessment could be based on all of this data, that this data was available for the parties to take into consideration. Without the data, then where would the parties be?
Well,
But I'm particularly thinking of the data
okay, so
to calculate Crown, first of all, NCRRs.
right. So this, I'll get to that point just now. Then, firstly, the Crown is the one making the decision, and the court's role is to review that decision in relation to the explanation given for it, and the Crown's explanation is in relation to these 5 factors, one of which is net benefits and expenses. That's the third factor. And the plaintiffs, and it's one of the 4 factors that are in a regular augmentation decision. My friends, for the plaintiffs and for the contingent interest First Nations, say that in a regular augmentation decision, these factors are directed to the present, which is what we say as well. The difference with the compensation decision is that there is a new factor, factor 1, nature and severity of the breach. That's first difference. Second difference is in relation to factor 3, where the time period for taking into account net benefits is changed from the relevant time frame to over time. The court made a deliberate change in the wording there. Relevant time frame is regular augmentation. Over time is we submit across multiple augmentation periods. There's a reference to that in our factum and support for it. And we say that's the whole period. So factor 3 considers net benefits across the whole period. Doesn't consider augmentations that would have or should have taken place. The court directs the Crown to consider net benefits in the same way that the Crown must in a regular augmentation period. So that's one change.
But do you point that out as a response or as part of your bring forward rate argument?
Yes.
Okay.
And the plaintiffs point to factor 1, which is nature and severity of the breach. And they say that the court, the Crown and the court must look to the effect of the breach on the Anishinaabe. And that requires, they say, looking at the amounts that would have or should have been paid. And the Crown says, well, the word effect is not in there. Factor 1 is nature and severity of the breach. Across time, nature, what was breached? An obligation to exercise discretion. Severity. Was it partial? Was it complete? Here it was complete and long-standing and egregious. And the plaintiffs refer to the Ward case and paragraph 52, which is at page 218 of the compendium. And they say seriousness of the breach means looking at the effect. But the Supreme Court in Restore didn't say nature, severity, and seriousness of the breach. It said nature and effect of the breach. So Ontario says, you look at the breach, the nature and severity of it, and then you look at net benefits, and you look at the other factors. But what you're bringing forward is net benefits. Because the court, directs a present polycentric decision, which is an implementation of the treaty promise for the whole period. So there's a present exercise of discretion. We're not looking at hypothetical past exercises of discretion. And
This is your argument,
yes,
I believe, in support of your order of calculation, order of determination, and that is that the polycentric considerations come before you determine a bring forward rate.
no, that's the plaintiffs. Well, no.
I went through this with you yesterday. I just hope I'm remembering correctly.
We say the opposite.
Yes, you say, look at the net benefits, apply an augmentation. We apply a bring forward rate, and then look at a number of things,
Yes.
consider a number of things, including polycentric policy demands,
Well,
before determining share.
yes, including harm. Sorry, not including needs.
But many, whatever those other are.
Yes, that is
So
correct.
first-
You have that.
First net benefits,
Yes,
then a bring forward rate,
yes,
and share determined through the lens of the other factors.
yes, but share actually isn't. Yes, share is the result. Another way of describing the amount.
It's not a determination.
Oh.
The amount is a global amount set by the Crown after taking into account all of these factors. And one might, as they say, what's that fancy word? Back engineer, re-engineer, what the share was.
Well,
You say share is not something in the exercise that the Crown engages in.
no, it's not directed to either in a present augmentation or in respect of the entire past. And then the Crown makes a decision as to an amount and as to explain it. The Crown has an obligation to choose the correct amount according to these factors. And the executive, is better placed to do that, because it has the expertise at polycentric decision making. It might be helpful, Your Honour, at this point to turn. I had my third submission. It's going to be truncated, but as part of that, a few minutes, as part of that, I want to take you to the explanation. which is in the compendium, because this follows on from what I was just saying. So tab 2, page 8479. So the minister chose a number that he considered would advance reconciliation and repair the relationship. And from paragraphs 10 onwards to 15, the minister explains how he considered the 5 factors in a polycentric way. He explained how he saw them working together. Paragraph 10. This is factor 1, long-standing and egregious breach. And the minister says, in the 3rd sentence, as a result, the Crown should consider the full amount of Crown benefits and expenses generated from the treaty territory. Factor 1, applying here to factor 2, means that you consider all net benefits. Paragraph 11, the minister's engaging factor 3. Sorry, I said factor 2 just before, didn't I? Engages factor 3, which is net benefits. Paragraph 11, engaging factor 3, we have the amount of shareable wealth. That's in the present. Paragraph 12.
Sorry, that's for what you call regular augmentations? The amount of shareable wealth. That's still a reference to the NCRRs.
Yes.
Thank you.
And then paragraph 12 explains, as my colleague will later, the bring forward rate that is used. Paragraph 13. This is an example of the polycentric nature of the decision, engages factors 2, 4, and 5. We have the first sentence, to reflect the RSFN's needs relative to non-Indigenous populations. That's factors 2 and 4. And the impact of intergenerational trauma. The minister later explains that that's under factor 5. It's taking ongoing impact of breach into account, present impact of long-standing breach. And then back to factor 2, reference to factor 3, 2. It's just and honourable for the $2.7 billion adjusted shareable wealth to constitute the floor of an honourable range. The minister says, we bring forward the NCRRs because of the needs in relation to other communities and in and of themselves, because of intergenerational trauma, those net benefits brought forward are the floor of an honourable range. And then the minister says, in this case, this is paragraph 14, referring to factor 2, it's just and honourable to make a rough estimate of indirect benefit. And then factor 5 in paragraph 15. To ensure that the ends of reconciliatory justice are met and in a spirit of generosity, it is just and reasonable to add an additional $225 million. The minister repeats this description in the overall conclusion, paragraphs 260 to 264. It's just a repetition of the overview, but later an explanation. So a description of the polycentric nature of the decision. And then the minister describes through the explanation, I won't take you to paragraphs because it's the whole thing, how he determined facts which make up the factors in relation to the evidence. And then I take you to one more paragraph in the explanation, give you some other references, and then sit down. Compendium page 8548 of my this is paragraph 258 of the explanation. This is the minister explaining what for him was the standard for the appropriate amount of past compensation. In the first line there, the question is what amount of an augmentation reflects the Crown exercising its discretion diligently, honourably, liberally and justly while engaging in an ongoing nation-to-nation relationship with the RSFN based on Anishinaabe values of respect, responsibility, reciprocity and renewal. The amount must also reflect reconciliatory justice. So the minister sets an amount and he says, this is how I know I've reached the right amount because it does these things.
So not to quibble, but the minister says in reaching an amount.
He says that's the question.
In exercising an amount, in exercising its discretion liberally to set an amount. I thought you made quite an effort to tell me that liberality had nothing to do with setting the amount.
Sorry, the word reflects this is the way the Crown is making the decision.
The question is what amount?
Yes, reflects the Crown acting liberally.
Reflects the exercise of discretion. The exercise.
The Crown.
I read it as the Crown exercises its discretion to set an amount.
Yes.
And the author of this letter says that they're exercising their discretion diligently, honorably, liberally, and justly.
Yes, they are. And I explained yesterday, though, when the court says liberally, with what it means is that it must be done in a polycentric way. That's what it says. It doesn't say a liberal amount. It says liberally means this. And so it's describing the manner of exercise of Crown discretion. So I'm going to give you references to a few paragraphs, which are the minister explaining what he understood about the nature of his decision. What the minister understood about the nature of his decision. Paragraphs 25, 26, 27, 30, 36, 43, 46, 47, 56. And these accurately and correctly describe the law that required the Crown to augment the annuities.
Thank you.
May I suggest, Your Honor, that we take a morning break?
All right, what's the, how are you doing with your time?
Doing well, yes. Oh, we're 15 minutes is fine as a result. We're doing well for the day, Your Honor.
Okay. Break for 15, thank you.
Thank you.
Course down for 15 minutes. This court is resumed. Please be seated.
Mr. Rankin, you're up.
Good morning, Your Honor. David Rankin for Ontario. Your Honor, my plan this morning, and I think it'll likely take the balance of the morning, is to cover the nature of this review proceeding and the role of this court in the review.
Thank you.
In terms of materials, I'll be referring to the hearing compendium of Ontario. And that should be it, Your Honor. Your Honor, this stage of our submission includes 4 points. So I'll tell you what those are and then I'll get into the details. My first point will be that this review proceeding is a judicial review. I don't say analogous to judicial review. I say it is a judicial review.
In the plain of the words?
In the meaning of the words in the law. So it's not just a review by the court, it's a judicial review, and I'll tell the court what that is and what principles are involved. I'll also get into why it matters to our arguments. And the short answer to that is the principles tell us what the standard of review is and how to apply it. And that's my second point. How to apply the deferential standard. I want to spend a bit of time on that second point, Your Honor, because with the greatest of respect to all of my friends, I suggest the court hasn't yet heard properly how to conduct a deferential review. There's a technique to it, and I submit that it's different from the model that has been urged upon the court. My third topic, Your Honor, will be to address what I say respectfully are my friends' major errors in asking for a correctness review. And I'll also cover the argument that it's not actually a binary, that there may be some third alternative. I'll cover that as well.
What's not a binary? Correctness versus
Deferential. Your Honor will recall that my learned friend for the Huron First Nations referred to it as being not a binary.
Mhm.
And there was a reference to how procedural fairness review is done. And I will address that and why that's not a proper analog.
Okay. Sorry, so your position is the position that it is not binary is incorrect.
Correct. It is a binary.
Is a binary.
There are two standards of review.
Telling you, you're always on thin ice when you give me double negatives.
I'll do my best to avoid that, Your Honor. Your Honor, the fourth and final point that I'll address this morning is the onus in a review. So I'll start with my first of the 4 points, and that is the nature of the proceeding. And as I indicated, this is a judicial review. Judicial review, Your Honor, is an old doctrine. And it fits exactly what the Supreme Court directed to happen in this proceeding.
And you're going to tell me that that's a conclusion I should make, that we should all come to, notwithstanding the court's, the court did not use that term,
Correct, Your Honor.
even though it's an old standard that we all know. And they chose their words carefully. And I just, partly I say that because I'm thinking of Mr. Ogden's comment. Here we are with not as much guidance as we might want from the Supreme Court. And you say, but there is guidance.
Your Honor, my submission will be that it is crystal clear in Restool that this is a judicial review. The court may not have used those words, but the court also wasn't engaging with the question of what jurisdiction this court engages when it conducts the review. Judicial review is the jurisdiction of this court. It's part of the court's inherent jurisdictions, and it's found in Section 96 of the Constitution Act 1867. Judicial review is the power of a superior court to review the exercise of state power that is public in nature. And Your Honor, I'm going to come back to that a few times. State power that is public in nature, because that's what triggers this court's jurisdiction, and that's what this review is about. Judicial review is inherent jurisdiction, so it does not depend on a statute. This is why I accept my friend's argument that Judicial Review Procedures Act doesn't apply. The Statutory Powers and Procedures Act doesn't apply. The Federal Courts Act doesn't apply. But this court's inherent jurisdiction does not depend on those statutes. What those statutes did was modernize judicial review for most administrative decisions. And the fact that those statutes don't apply here just means we're going straight to this court's inherent jurisdiction. And fortunately, there's a body of legal principles that govern how that jurisdiction works. Now, Your Honor, given my friend's submissions last week, I suggest that I need to cover some foundational concepts about judicial review as part of this court's inherent jurisdiction and about administrative law more generally. First, I'll address the suggestion by some of my friends that administrative law does not apply. And this is where I need to do a bit of resetting. Administrative law is a field of law that governs what's known as the, quote, administrative state. The administrative state consists of all decision makers which exercise state power that is public in nature. It includes everything from ministers of the Crown and Cabinet making multi-billion-dollar decisions, all the way down to the more day-to-day, which is sometimes known as the pointy end of the administrative state, the state interacting with individuals. It's all covered by administrative law. Ms. Evans took the court to a paragraph of Vavilov, making the point that the administrative state is diverse. That was paragraph 88 of Vavilov. And I'm not going to go back there. And Your Honor, just as an aside, I'll note that I'm not going to go back to things that Ms. Evans covered. There will be one exception, which I hope the court allows me to do, but generally speaking, I'm not going to go back to paragraphs Ms. Evans took the court to.
So just so that I'm clear, do you adopt these submissions by Ms. Evans, or do you distinguish?
In
Your
substance,
position.
yes, there are a few points of nuance, Your Honor, which I will come to.
And when you say this court has not heard correct interpretation of standard of review, do you include in that any comments by Canada?
I want to be clear, Your Honor, that I'm not criticizing my friends here, but there are some paragraphs of Vavilov that I need to take the court to about what judicial review involves and what it does not involve. And that's what the court has not seen yet, at least in the context of the oral argument. Now, Your Honor, my point in talking about the administrative state right now is simply that the diversity of the administrative state, which is covered by administrative law, is reflected in the principles. It's reflected in the flexibility of the, quote, administrative law approach. The administrative law approach is a phrase that I've borrowed from Justice Abella in the Dore case, which this court has heard about. One of the themes of my submission will be that the administrative law approach is rich and it's expansive and it's robust. The administrative law approach takes its color from the context. That's a quotation from Justice Binney in a case called Cosa. I'm going to come back to that a couple of times. It takes its color from the context. And that includes the honor of the crown. It's a flexible approach, the administrative law approach, and it fits the solemnity of this case. And I'll have more to say about that when I get into how deferential review works. But it's key to recognize that the administrative law approach is robust and flexible and takes its color from the context. The next foundational point that I'd like to cover, Your Honor, is precisely what engages this court's inherent jurisdiction of judicial review. And I've prefaced that by indicating that the court's jurisdiction is engaged by state power that's public in nature. Now, in fullness, there's a third element that's a judiciable issue. That's not a debate in front of it, Your Honor. We all recognize there's a judiciable issue here. So what we're looking for is state power that's public in nature. And then this court has the jurisdiction of judicial review. And we have all of that here. And I'd like to take the court into the Supreme Court of Canada's leading case on the availability of judicial review to emphasize and confirm that point. And this is at tab 7 of Ontario's compendium, Your Honor. It's the Highwood Congregation of Jehovah's Witnesses Judicial Committee and Wall case. Tab 7, it's case lines B18595.
Go ahead.
This is the case, Your Honor, where the Supreme Court of Canada set out the trigger for the court's jurisdiction over judicial review. I'll take the court to paragraph 13. Justice Rowe writes, "The purpose of judicial review is to ensure the legality of state decision-making." And then there's a number of citations. It picks up judicial review is a public law concept that allows Section 96 courts to engage in surveillance of lower tribunals in order to ensure that these tribunals respect the rule of law. The state's decisions can be reviewed on the basis of procedural fairness or on their substance. Then down at paragraph 14, Your Honor, and this is the key point. In the second sentence, judicial review is only available where there is an exercise of state authority and where that exercise is of a sufficiently public character. Your Honor asked one of my friends last week whether authority and power are interchangeable. I use them interchangeably, Your Honor.
Yeah.
Now, Your Honor, when I read these paragraphs, there is a point about the language that I always like to identify. When Justice Rowe writes state power, he does not say statutory power or statutory authority. It doesn't say where there's an exercise of statutory authority, it says state authority. State authority includes statute and it includes the Crown prerogative.
I don't think there's any real argument whether this is an exercise of statutory power.
Correct. It's not an exercise of statutory power. And some of my friends have suggested that because it's not statutory power, we're not in the world of judicial review. We're not in the world of administrative law. This is the point that I'm rebutting because I strongly disagree with that point, Your Honor. State authority includes prerogative power. Power is not sourced in a statute. And it should not be controversial, Your Honor, that the power at issue here is finding its source in the Crown prerogative. The Supreme Court noted that in Restool itself, it's at paragraph 166. I'm not intending to go there, Your Honor, and the reason why is because it's actually necessarily true. If the state power is not sourced in a statute, then it must be coming from the Crown prerogative.
Mm-hmm.
This is not, to use a phrase of one of my friends last week, an analogy to Crown prerogative. This is Crown prerogative. Now, one of my friends last week made an interesting argument in oral submissions. There was an argument that the source of the power here isn't the prerogative, but the treaty itself. And with respect, that argument is based on a mistaken view of the nature of Crown powers. The Crown only has those powers that it receives from the legislature or from the monarch. That's the royal prerogative. Again, in completeness, the Crown also has powers as a natural person, but those aren't state powers and they're not at issue here. The treaty-making power is well established as being within the Crown prerogative. And I'll just give the court a citation for that. It is in our factum, but it's the Hupuchesset First Nation case. I'll spell that for the reporter. Hupacasath, Hupuchesset First Nation. And the citation, Your Honor, is 2015 FCA 4, paragraph 33. That's the source of the Crown power here. Of course, the treaty imposes constraints on the power. And I'll talk about how constraints operate within administrative law. But the power here is grounded in the royal prerogative. One of my friends last week, Your Honor, said that a quote, regular judicial review is about the exercise of statutory grants of power. And I've already responded to that, but I want to respond a little bit deeper by bringing the court to a leading textbook on administrative law. This is Professor Mullen's text, Administrative Law, at tab 8 of my compendium. Now, Your Honor, this is now a fairly old text. I believe it was published in 2001. The reason why I like going back to this text is because Professor Mullen sets out the core principles, where judicial review came from, and what it is today. And it's been cited quite a number of times by the Supreme Court of Canada as well. So I still find the book useful, even though it's over 20 years old. The page in the compendium is page 50. I believe it's been cut off by the court file stamping, but it's 8598 of case lines. I'll read, Your Honor, the second sentence of that first complete paragraph. The superior courts have always claimed and been recognized as having a superintending authority over all exercises of state power that are justified by reference to a statutory or prerogative source. And then it goes on to talk about delegates of parliament. The delegates of parliament, including all inferior courts and tribunals, are creatures of limited jurisdiction. And among the inherent functions of the royal or superior courts has always been policing those limits. That's what this review is about. Something new about that. Courts have always claimed and been recognized as having that superintending authority to review the exercise of state power. So what we're doing here today, these weeks, is something very old, something superior courts, this court, have always done. It's called judicial review. Now, last week, Your Honor asked some of my friends whether there was precedent for this sort of review in the treaty context. I didn't hear my friends identify any cases, but I disagree with that approach. Because respectfully, Your Honor, courts, especially the divisional court, they do engage in judicial review of Crown discretion under treaty.
Are you saying especially divisional court?
Especially divisional court. I'll take the court to an example in a moment. And I would submit that it's not even that uncommon. Because it comes up in the context of judicial review applications involving the Crown's exercise of discretionary taking up clauses in treaties with Indigenous peoples. I know this court is familiar with taking up clauses because that's what Grassy Narrows is all about. And we spoke about Grassy Narrows a little bit less than 2 years ago in this very room. But just very briefly, Your Honor, the Crown has discretion under some treaties, such as Treaty 3, to take up land for settlement and other purposes, and that gives rise to a duty to consult under treaty. These cases are routinely dealt with on judicial review. I'll take the court to an example from the divisional court. This is the Wabauskang First Nation and Ontario case. Your Honor, this is in our factum, but it's not in the compendium. So I'll ask my colleague, Mr. Salama, to put it on the board. The citation, Your Honor, is 2025 ONSC 316 Divisional Court.
Could you also please give me your factum reference?
Of course, Your Honor. I'll look for that as I speak. Now, this was a judicial review application in relation to decisions to take up land under Treaty Number 3. And Your Honor, there's a citation in our factum at footnote, this is the main factum responding to the plaintiffs, footnote 50.
Thank you.
Wabauskang First Nation case. And I'll take the court
Give me
to,
the footnote. Would you give me the paragraph reference?
oh, my apologies, Your Honor. I closed my book. That would be paragraph 49, Your Honor.
Thank you.
I'll take the court to paragraph 1 of this case, and it's Justice Shore writing. The applicants, Wabauskang First Nation and Lac Seul First Nation, apply for judicial review of 2 decisions of the respondents, which were emanations of the Crown, to take up land pursuant to Treaty Number 3 without the Crown first discharging their constitutional duty to consult the applicants. This is a judicial review application of the exercise of state power under a treaty. Now, Your Honor, while I'm here, because I don't want to have to pull up this case again, I'll point out something about the standard of review in duty to consult cases. There was some suggestion last week, Your Honor, based on an article from the Alberta Law Review, that there was uncertainty around the standard of review in consultation cases after Vavilov. With great respect to my friends, there is no uncertainty in Ontario. The divisional court deals with this. The divisional court is clear. This is a 2025 case. And the standard of review is precisely what we set out in the factum. At the beginning of a process, there's a decision about the existence and scope of the duty to consult. That is reviewed for correctness. But the adequacy of the consultation, which is a decision made at the end of the process, that's reviewed on the reasonableness deferential standard. And that's the law in Ontario. I'll take the court to paragraph 70 if I could. As set out above, this is the second sentence. As set out above, the adequacy of the consultation is reviewed on a reasonableness standard. Perfection is not required. And there's a citation to Haida Nation. I have a final short point on my first topic about what is this proceeding. And this is just a quick note arising from the submissions from Canada. Ms. Evans noted that this review had an unusual feature insofar as the federal crown is involved. It's a federal decision before the court being reviewed by an Ontario court. And I just wanted to briefly address that so there's no confusion about this, Your Honor. This court does have jurisdiction to review exercises of federal prerogative power. The Ontario Court of Appeal said that in a case called Black and the Prime Minister. It was a case about Conrad Black seeking to become a member of the House of Lords in United Kingdom, and the Prime Minister at the time gave some advice to Her Majesty the late Queen regarding that, and there was a proceeding brought in Ontario courts in respect of that. I'll just give the court the citation. Nothing really turns on this. I just want to make it clear that the presence of the federal crown here doesn't make this any less a judicial review. And that citation, Your Honor, is 2001 Canley 8537. It's paragraphs 75 and 76. And that's the Ontario Court of Appeal.
And it's Black versus, is it the named Prime Minister?
The way that it's reported, Your Honor, is Black and Canada brackets Prime Minister.
Thank you.
It was Prime Minister Chrétien, but that's not indicated in the style of cause.
Thank you.
Your Honor, subject to questions on my first topic, I will move on to my second, which is to drill down on deferential review.
Please go ahead.
In judicial review, there are two standards of review. There is correctness, which is the de novo standard. And one could call it either correctness or de novo. They're synonymous. The other standard is the reasonableness standard, which is the deferential standard. And again, you could call it either. They are synonymous. Reasonable or deferential, it's the same standard. The standard of review in this case is the deferential standard. That's the default standard. And Ms. Evans already referred the court, I'm not going to go back there, but Ms. Evans already referred to the language in Restool itself, indicating that the Crown is entitled to a degree of deference within a range of honorable results. It's paragraph 308. That is the deferential standard of review. Some of my friends argue for a correctness standard, and I am planning to go on and say why I disagree with that, Your Honor. But first, I think it's important for the court to hear exactly what the deferential standard is. And I want to spend some time on this, as I indicated, because respectfully, some of my friends have not properly advised the court about what the deferential standard involves. My friends have made submissions, and I say this with respect, that if followed would lead this court into very significant error. My friend's approach, or the approach of some of my friends, where only a court can decide questions of fact and law, goes against decades of jurisprudence from the Supreme Court of Canada, moving away from what was known as the court-centric approach to administrative law. Some of my friends have gone so far as to suggest that deference on factual questions is equivalent to unfettered discretion. And as I hope to persuade the court, That is not how the deferential standard works. I'll start with what the deferential standard is, and then I'll turn to what it is not. Both are equally important. Deference is an attitude of the court and a specific way of approaching a review. The clearest articulation is found in Vavilov, and this is a paragraph I don't believe the court has been taken to yet, paragraph 99. There are a number of other paragraphs leading to that which provide elements of this, but paragraph 99 brings it all together. So I will take the court there. This is in our compendium, tab 10, case lines B1 8603. Paragraph 99, Your Honor.
Thank you.
I'm going to take this in two parts. A reviewing court must develop an understanding of the decision maker's reasoning process in order to determine whether the decision as a whole is reasonable. And I'm going to pause there. Decision as a whole is reasonable. The deferential standard looks at the decision holistically. I'll take the court to some other cases, including Section 35 cases that make that point expressly. But I want to leave Your Honor with that concept right at the beginning. The deferential standard is not an exercise in segmentation of subordinate elements with different standards of review. It's applied to the entirety of the decision. The rest of this paragraph, Your Honor, may, at least in my view, be the most important words in all of administrative law. To make this determination, the reviewing court asks whether the decision bears the hallmarks of reasonableness, justification, transparency, and intelligibility, and whether it is justified in relation to the relevant factual and legal constraints that bear on the decision. That's not a two-part test, but there are two parts to it. The first part is, does the decision bear the hallmarks of reasonableness? And that is an inquiry into the reasoning process. Is it coherent? Does it explain itself? The focus is on how it's reasoned. The second part relates to the result or the merits. Is it justified in relation to the factual and legal constraints? So there's that word constraints again. The factual and legal constraints vary depending on the case. And that's where we get the saying, courtesy of Justice Binney, in a case called COSA, reasonableness is a single standard that takes its color from the context. And Your Honor, that's in Vavilov itself. It's actually on the same page of the compendium. Paragraph 89. So reasonableness, the deferential standard, it's a single standard. It takes its color from the context. The context here includes, very importantly, the Supreme Court's decision in Restool. It includes the interpretation of the augmentation clause that the Supreme Court provided. It includes the honor of the crown. We know from Restool that the decision or the discretion must be exercised diligently, liberally, justly, honorably. Liberally in relation to all Her Majesty's subjects or His Majesty's subjects. These are the legal constraints that operate within the deferential standard. They are not threshold questions, as some of my friends have suggested. They operate within the deferential standard. That's what it means to say that reasonableness takes its color from the context. That's the color.
That, so takes its color from is an important, as you say, approach to the review. But you seem to come to that line in response or in refuting your friend's suggestion that there is a threshold question. Help me with that link, please.
Some of my friends, Your Honor, suggest that the court first asks, was the decision honorable? And then maybe there's some deference after that. So sort of a two-step process. What I'm saying is that the deferential review, it's a one-stop approach. And within the deferential review, one looks at what are the legal constraints. And the question is the decision justified in relation to those legal constraints? It's all within the deferential standard. It's not one standard that's applied to a threshold question and then deference is applied subsequently. It's one approach. It's the deferential approach.
And your remarks are particularly directed to the amount determination?
The amount determination is the decision that the minister made.
Yes, but I'm distinguishing that from the engagement process.
Your Honor is entirely correct.
So your remarks are directed to setting the amount, and you say apply the deferential standard to the amount and to the reasoning, to the justification and transparency of setting that amount. So let's say to the letter of January 27th.
Correct. As I'm going to come to, Your Honor, reasonableness, the deferential approach it's a reasons-focused, reasons-forward approach. You start with what the minister decided and how he decided it, and you look to whether there's justification in relation to the legal constraints. Those legal constraints include the honor of the crown. They include the requirement to exercise the discretion diligently, liberally, justly, honorably. This is why my colleague, Mr. Ogden, indicated that the Anishinaabe perspectives, the values, the principles, those are constraints in the administrative law sense. They operate within the deferential standard. And Your Honor, as the review court looks to whether the minister's decision is justified in relation to those constraints. Not as a threshold preliminary question, but within the deferential standard.
When you say not as a threshold preliminary question, you're saying don't take one of the many constraints and look at it to see whether it is reasonable, but look at all of the constraints. Is that the point you're making?
That's part of the analysis, yes, Your Honor. What you're looking for is whether the decision is justified in relation to all of those constraints.
So for me to get this right, it's not a threshold preliminary question, you say, with respect to any particular constraint, but look at, as a court of appeal might say about a trial court decision, read it as a whole.
Your Honor is completely correct.
So then I will start to think that your references to the exercise of discretion with respect to the amount is the entirety of the January 27th letter, that should be the court focus.
That is the focus. And when I'm up this afternoon addressing some responses to my friends, I will be grounded in the minister's letter for that reason, because that's how you conduct a deferential review. Now, Your Honor, I indicated that I was going to cover what it is and then what it's not, because those are both equally important. So I'm turning now to what deferential review is not. And what it's not is a de novo determination by the reviewing court of facts and law. And for that, I'll turn the court to paragraph 83 of Vavilov. It's just the prior page in the print compendium, page B18602. It says, it follows that the focus of reasonableness review must be on the decision actually made by the decision maker, including both the decision maker's reasoning process and outcome. That's what we covered before. The role of courts in these circumstances is to review, and they are, at least as a general rule, to refrain from deciding the issue themselves.
You distinguish that from the remedy that the Supreme Court provided.
Yes, Your Honor, and I'm going to come to remedy, but just I'll preface
You're
my
saying that's in the
comments.
review process. That the court should refrain from coming to its own decision. You're saying post-review process, then the Supreme Court directs the court what to do. If there's a decision on, as you say, on a deferential basis, the court says the decision does not meet the reasonableness standard. It, in fact, does substitute, or it can substitute its own opinion, which presumably requires, I'm not sure if you're saying this, a de novo determination.
So, Your Honor, on the remedy, I'll just preface the arguments. The Supreme Court, of course, says that after the review, the court could, as a remedy, either remand back or substitute a decision. And what I will submit, I'll submit now, and I'll take the court back to this with some citations, is that the references there that Justice Jamal made in Restuhl actually reflect administrative law itself. Because in administrative law, the reviewing court can do both of those things. It can remand back, or in some circumstances, it can decide. It is exceptional in the latter, but there's guidance from the Supreme Court of Canada, and it's in Vavilov, and I believe it's paragraph 141, that explains how that works. But the point being that there's no inconsistency between what I'm saying deferential review is not and what Justice Jamal said can happen as a remedy in this case. Now, I'm still on paragraph 83 because the rest of this paragraph sets out a number of things that the Supreme Court said that a reviewing court should not do on a review. And respectfully, some of these points are things that my friends have asked the court to do in the context of this review. I'm starting with accordingly. Accordingly, a court applying the reasonableness standard does not ask what decision it would have made in place of that of the decision maker, attempt to ascertain a, quote, range of possible conclusions, that would have been open to the decision maker, conduct a de novo analysis, or seek to determine the correct solution to the problem. The court then goes on to provide another metaphor. Administrative law has a lot of metaphors, Your Honor. A metaphor of a yardstick. And this one is courtesy of Justice Stratus in the Federal Court of Appeal. As reviewing judges, we do not make our own yardstick and then use that yardstick to measure what the administrator did. Your Honor, I say respectfully that some of my friend's submissions last week should be compared to this paragraph. Some of my friends for the plaintiffs have said that the court identifies a range of acceptable outcomes. There was a suggestion, and this is in some of the reply factums as well, that the range must be identified by the court. That was a theme of some of my friends' oral submissions last week. But respectfully, it's incorrect. The court conducting a deferential review does not ascertain its view on a range. That's black and white. That's Vavilov.
And how does one deal with the proposition then that the test of honor, or that the deferential review allows the court to look at a range of options? Where does the range come from?
The range of options, Your Honor, again, many metaphors in administrative law. It's sometimes described as a margin of maneuver. What's the margin of maneuver that the decision maker has? There was a time in administrative law, because administrative law has gone through in the last decades, as Your Honor knows, some major revisions. There was a time in administrative law where decision makers would try to identify what the outer bounds were of that range of maneuver, range of outcomes. It was sometimes referred to as a lot of deference or a little deference. The Supreme Court in Vavilov was clear that you don't try to identify what those outer bounds are. What the court should do is look at whether there's justification in relation to the legal and factual constraints. And in some cases, the legal and factual constraints will be wide, sometimes they will be narrow. Where you're looking at a decision that is in the public interest, and I would submit a decision such as what was before the minister, that margin of maneuver is wider compared to a more narrow statutory power, for example. But nevertheless, in conducting the review, the reviewing court does not try to identify what those outer bounds are. A determination that the decision is not justified in relation to the legal and factual constraints is equivalent to saying it's outside the bounds, but one does not define the bounds.
Well, how does one look at the range of honorable outcomes?
What I would submit, Your Honor, is that one applies the principles of deferential review. And in a very short amount of time, I'm going to take the court to 4 principles that should be applied. And that those principles are what determines whether something is inside or outside that bound of honorable, but the court does not try to identify a range. So it would not be correct for the court to say that the range of honorable outcomes are from X billion to Y billion. 3.6 is outside of that range, therefore it's unreasonable. That's not the way the deferential review works. And I would submit respectfully that some of my friends commit the same error in their approach to the factual constraints. Some of my friends say that it's for the court to decide the factual elements that underlie the minister's decision. Some of my friends say that the facts here are objective historical fact and thus for the court to decide. But again, that's black and white in Vavilov, not what the court on a review is intended to do. And for that, I will stay in Vavilov and take the court to paragraph 125, describing it as, quote, trite law, that it's for the minister to evaluate the evidence and assess the facts. And this is an important point, so I will read at least the first two sentences of the paragraph. It is trite law that the decision maker may assess and evaluate the evidence before it, and that absent exceptional circumstances, a reviewing court will not interfere with its factual findings.
I'm sorry, can you give me the paragraph reference again?
My apologies, Your Honor. It's paragraph 125.
Thank you. Got it, thank you.
And I'll pick up with the second sentence, Your Honor. The reviewing court must refrain from reweighing and reassessing the evidence considered by the decision maker. And then there are a few citations, including COSA, which is where Justice Binney penned that saying, color from the context. There's nothing at all unusual, Your Honor, about a minister of the Crown making factual determinations. It happens every day, including in the duty to consult context. Ms. Evans took you to Haida Nation, making that point as well. But one thing is clear from all of this, and this goes back to a question that Your Honor asked some of my friends last week about fact-finding. In a review, the court's role is not to engage in fact-finding. Now, Your Honor asked, how do we do this then? And this is where I come to the how-to of deferential review, the principles. I said at the start, Your Honor, that there's a technique to it. And for this, I'll take the court into paragraph, or my apologies, into tab 11 of Ontario's compendium. And this, Your Honor, is the chart from Ontario's factum. I believe this is being referred to as the chart. Now, Your Honor will know that from our factum, the reason we included this was to show that the principles from Vavilov and the principles from Restool line up pretty well. My purpose for taking the court to this chart now is for a slightly different purpose, and that's to use it as a collection of principles for the how-to of deferential review. But first, I want to point out something structurally about this chart, Your Honor. What we've done is on the left-hand side included the principles from Vavilov. And on the right-hand side, Restool. There's a reason it's in that order. And it's because Vavilov is telling us how the deferential standard works. And it's telling us that it takes its color from the context. So Your Honor can see this as being the general. And then we move to the specific, the color from Restool. So they're general propositions on the left, and we move to the specific propositions on the right. They are articulations of the same principles, but tailored for this context. I'll also point out, Your Honor, that there are 4 rows in this chart. They correspond to what I will submit are the 4 key principles of deferential review. First, and most importantly, the reviewing court starts with the reasons of the decision maker. That's the first row. Deferential review is a reasons forward process. It is not possible to conduct a deferential review in the abstract. It can only be done by looking at specifically how the decision maker reasoned through the question to the answer. The second row is the next key principle. When analyzing the reasons, the reviewing court does so by paying respectful or careful attention to understand why the decision was made. So it's a reasons forward approach, and this is what the reviewing court looks for. And then the third row, which is over on the next page of the compendium, this is the principle that the reviewing court must be attentive to the expertise of the decision maker, here or the Crown. The Supreme Court held in Restool that the Crown has expertise in the sort of complex polycentric decision-making at stake with the augmentation clause. The reviewing court is attentive to that. And then the fourth row is the principle that courts should exercise considerable caution when interfering with executive decision-making. So there are 4 rows with 4 principles. It's reasons first. It's careful or respectful attention to the reasons, attentive to expertise, judicial restraint. And that's how deferential review works. This is robust as a process, but it's how to conduct a deferential review. Now, Your Honor, subject to any questions about that topic or the chart, I would move on to the discussion of what I suggest are some of my friend's major errors in seeking a correctness review.
Thank you.
And I have 5 errors, I say respectfully, that I would urge on the court as undermining some of my friend's arguments. The first error that I want to address is something I noted at the very beginning, and that's the idea that deferential review and de novo review are not exhaustive. My learned friend for the Huron First Nations last week, and I think it was on Friday, suggested it was a false binary to say that there's de novo and there's deference. And the comparison was to the way that reviewing courts review procedural fairness. In the procedural fairness context, the courts don't apply a standard of review. Now, there was a lot of case law where there was some wrestling about that question. The way it lands, I would submit to the court, is that there is no standard of review for procedural fairness. And if I understand my friend's argument, it's that shows that it's a false binary because there could be a third option where there is no standard of review. But respectfully, my learned friends are overlooking a basic principle of administrative law. In judicial review, there are two basic types of challenge. There's procedural fairness on one hand, and there's substantive challenge on the other. Substantive challenge is sometimes referred to as merits challenge. The leading case on procedural fairness, it's a case called Baker from 1999. It's been cited by some of my friends, but that's about procedural fairness. The leading case on substantive review, merits review, that's Vavilov. The standard of review concept belongs to substantive review. It's not part of procedural review. There's a reason for that. In substantive review, we need a standard of review against which to measure the merits of the decision. When you're in substantive review, you need a standard of review. This case, before your honor, involves substantive review. The Supreme Court was clear that the augmentation clause is not limited to procedural duties, it's substantive. So when the court is reviewing the merits of the result, the decision, we need a standard of review. And there are only two possibilities known to the public law: de novo and deference. This case is deference. The second error, Your Honor, that I'll cover is I say respectfully that my friends are wrong in attempting to reconcile the correctness standard with the language in Restool of some degree of deference from paragraph 308. Correctness and deference are oil and water. They do not mix. They start from different places. The review is done differently. Correctness is de novo. It means by definition, the absence of deference. If there's deference, the standard of review is deference. And it is as simple as that. The Supreme Court made that clear in Dunsmuir, which was the Vavilov before Vavilov. It's in our compendium at tab 12. And I will take the court there because this is an important point. And it's paragraph 50, Your Honor, and that's in case lines, page B18613. So it's paragraph 50, Your Honor.
Yep.
And I'll take the court into the middle, if your honor is looking at the version in our compendium, it's the middle of the paragraph, which is bolded. When applying the correctness standard, a reviewing court will not show deference to the decision maker's reasoning process. It will rather undertake its own analysis of the question. So that's what correctness review is. It's where the court doesn't start with the reasons. It starts with its own view of what the right answer is. You can't apply both standards at the same time because they start from different places. Your Honor, the third area that I wanted to cover, I've touched on briefly, but I do want to take the court into some cases to support my argument, and that's the argument that my learned friend for the Huron First Nations raised, that deference is owed after the court is satisfied that the Crown's decision is honorable. And that was presented in oral argument, and it's also in the factum of the Huron First Nations, paragraph 18. Now, as I understand this argument, there's a sort of a two-step process. There's correctness on isolated issues first, and then there's deference. And my friend for the Contingent Interest First Nations made a similar argument last week, urging the court to split up the minister's decision into subordinate parts with different standards of review. And respectfully, the Supreme Court has been clear that this is not how to conduct a review. And I want to demonstrate that with another Section 35 case. And this is at tab 13 of our compendium, the Tanaha Nation and British Columbia case from 2017. This case, Your Honor, was referred to by my learned friend for the Huron First Nations, and it was also referred to by Ms. Evans. As Your Honor heard, this is a judicial review of a minister's conclusion that the Crown's constitutional obligations under Section 35, duty to consult obligations, were satisfied. And the Supreme Court held, as Your Honor heard correctly, that deference was the standard of review, and it was incorrect to attempt to isolate constitutional issues to review de novo. And Ms. Evans already took the court into paragraph 77. And this is the one example, Your Honor, where I wanted to go back to something that Ms. Evans referred to and read from. And the reason why, Your Honor, is because I want to emphasize some slightly different words. And it's in the last sentence of this paragraph. Before I read it, I'll just indicate the words I want to emphasize. These are words from Vavilov I mentioned before, on a whole. So I'll read it in context. A reviewing judge does not decide the constitutional issues raised in isolation on a standard of correctness, but asks rather whether the decision of the minister on the whole was reasonable. It's a holistic analysis. And again, the reason is because of the way deferential review works. And then the Chief Justice and Justice Rowe go on in paragraph 82 to emphasize that point. Paragraph 82, middle of the paragraph in bold. As noted, a court reviewing an administrative decision under Section 35 does not decide the constitutional issue de novo for itself. Rather, it must ask whether the administrative decision maker's finding on the issue was reasonable. The administrative decision maker there was a minister of the Crown, just like this case. Discretionary decisions under section 35 are reviewed on a deferential standard on a whole. Deference is the starting place of that analysis. It's the framework for how to conduct the review. Now, briefly, before I move off this case, I want to address the way that my learned friend distinguished the case last week. And I can be brief on this. The argument was that this was primarily about a statutory decision, and it came before Vavilov, about 2 years before Vavilov. But respectfully, I've already taken the court to the Wabascang First Nation case from the divisional court from this year. The standard of review on the adequacy of consultation is confirmed in Ontario as the deferential standard. And equally as importantly, that was a case involving Crown discretion under treaty. So Ktunaxa Nation remains good law. It applies in the treaty context. This leads, Your Honor, to what I suggest would be the fourth error that I wanted to cover. And that's my friend's argument that the standard of review is correctness because this case has been styled as a review for constitutional compliance. Constitutional issues attract correctness, and Your Honor was taken to a paragraph from Vavilov on that point. But respectfully, my friend's submissions on this are mistaken. My friend Ms. Evans covered a lot of the case law on this. I'm not going to go back to that, but I want to pick up a discussion or an exchange that Your Honor had with Ms. Evans about the significance of the decision being discretionary in this context. The case law is clear that discretionary decisions are reviewed on the deferential standard, including where they engage constitutional rights. And for that, I'll take Your Honor to a recent Supreme Court of Canada case at tab 14 of our compendium. This is the Commission Scolaire Francophone case. It's in the compendium page B18618. Now, this was a case about language rights and values under the Charter. And it makes the point very clearly that discretionary decisions that unjustifiably limit charter rights are reviewed on the deferential standard. I'll take the court to paragraph 60. In Doré, the court has heard about Doré. In Doré, this court, for Justice Abella, established an approach for reviewing discretionary administrative decisions that limit charter protections. Justice Abella found that reviewing courts must show deference to decisions of that nature. That's a very recent case from the Supreme Court of Canada. It remains good law, as does Doré. Some of my friends referred to a more recent case, which makes it a very recent case, called York Region from 2024. Ms. Evans already set out how that case did not overrule Doré, did not overrule Commission Scolaire from the year before. I agree with all that. I won't cover that ground again. But what I want to point out, Your Honor, is that York Region isn't on point at all because it didn't involve a discretionary decision. So it's unlike Doré, it's unlike Commission Scolaire, it's unlike this case. York Region was about a labor arbitrator who was wrong about whether the charter applied to school boards. And because of that error, didn't apply the charter analysis. So that case, the way it was presented at the Supreme Court, was about the scope of the charter, not about the discretionary implementation of charter rights. The labor arbitrator never got to that question. So what was before the Supreme Court was a binary question, whether the charter applied or it didn't. There was a correct answer to that question. Wasn't discretion, wasn't a range of options. So York Region is just not applicable. And I go back to where I started. With discretionary decisions, they are reviewed on a deferential standard, including where they raise constitutional constraints. The constitutional points are the constraints within the decision, the deferential standard. But it's still the deferential standard. I'll turn then to what I would describe respectfully as the fifth error.
I just want to make sure, it might be a very quibbly point. When you say the constitutional points are the constraints within the decision, they're the constraints imposed on a decision maker. Do you say that?
They are the
Like the word,
constraints.
the concept, the notion of constraints.
Yes. That's why it's not an unfettered discretion. That's what that phrase means in administrative law. Unfettered discretion is an administrative law concept, and it just means that there are constraints. There are constraints on the exercise of discretion. So on to what I say respectfully is the fifth error. Some of my friends say that the issues before the court involve treaty interpretation as opposed to implementation. Treaty interpretation, as we all know from Restool, is on a correct standard. But respectfully, this review is about implementation. If what was presented to the minister and now presented to the court was a question of interpretation, it would necessarily have implications for the future, for all time. That's what it means to interpret the treaty. There's an important distinction between interpretation, which the Supreme Court did in Restool, and implementation, which is what the minister did, as directed by the Supreme Court in Restool. Now, some of my friends say that that's an artificial distinction. But respectfully, it's not. It's an important distinction. Now, as I understand my friend's argument on this point, they say that the Supreme Court's interpretation of the treaty promise here was, quote, not complete. And I believe that's in the reply factum of my learned friends from the Huron First Nations. But respectfully, the Supreme Court said otherwise. The Supreme Court said several times that it was definitively interpreting the augmentation clause. The Supreme Court did not send the minister off to interpret the clause. The interpretation work had been done. And I'll take the court to Restool itself, tab 1 of our compendium on that point. And the paragraph I'd like to draw your honor to is paragraph 278. which is case lines, page B18455.
Thank you.
Justice Jamal writes, in my view, a declaration is an appropriate remedy in that it will offer a definitive statement of the rights and obligations under the augmentation clause to guide the parties in negotiating compensation for past breaches and to encourage the renewal of the treaty relationship moving forward. He made the same point down at paragraph 292 at page 8461. Now that this court has finally determined the Crown's obligations under the augmentation clause. So the minister wasn't asked to interpret the treaty. The Supreme Court gave the minister, both ministers, the definitive and final interpretation of the treaty and directed its implementation. And that's what the minister did. And the standard of review is deferential, and the decision is reviewed as a whole.
Small point. This court, the Supreme Court, never referred to the crowns in plural.
Correct.
Or the ministers in
Correct.
plural.
Your Honor is entirely right. What I meant to say was that the Crown was directed, and in response to that direction, both ministers implemented. Now, Your Honor, I'm noting the time, and I do believe that I can finish my last of the 4 topics before the lunch break. That's the onus.
Go ahead.
Now, I say respectfully that my friends are incorrect where they say that the onus lies on the Crown in the review proceeding. I need to be very clear about an important distinction in administrative law. There is a distinction between justification and onus. The Supreme Court said that the Crown must explain and justify the decision. It's paragraph 290. There's no surprise to an administrative law lawyer in that statement, because it's a basic principle of administrative law. Where the Crown exercises discretionary powers, it must be justified to the persons who are subject to it. Babel law talks about that. That's an old concept. The form of justification varies. Sometimes it's formal reasons, sometimes it's less than that. In this case, it's formal reasons. It's all very typical. It doesn't follow from that in a review where a party is seeking a different outcome, that there's a reverse onus. The onus is on the party who's seeking the different outcome. So in a judicial review, the decision maker provides a justification. And in litigation, to challenge that decision, the onus is on the party challenging the decision to show a flaw, a sufficient flaw with the justification. It goes hand in hand with a deferential standard. And I'll take the court into Vavilov again on this, because it's the most recent or clearest statement from the Supreme Court of Canada. And that's at tab 10 of our compendium, Your Honor, and it's paragraph 100. And it's B18603. The majority writes, the burden is on the party challenging the decision to show that it is unreasonable. And I'll commend the entire paragraph to Your Honor, but I'll just jump down to the last sentence. Indeed, the court must be satisfied that any shortcomings or flaws relied on by the party challenging the decision are sufficiently central or significant to render the decision unreasonable. So again, that's a function of deferential review being looking at the decision as a whole. Does the flaw that's being alleged mean that it renders the decision as a whole unreasonable? So, Your Honor, the law is clear that in a review, the onus is on the challenging party. It's a basic principle of administrative law. Chair, subject to questions on that concludes my section on the nature of this review and the court's role in the review. It takes us close to 12:30.
Seems like a good time for a break.
I would agree, Your Honor.
How are you on on the outline for your team? Vis-a-vis the end of the day, or how long for lunch?
Your Honor, I was exactly what I anticipated, almost to the minute. So we're doing well.
So a return at 2, does that?
Return at 2 is perfect.
That works for your timing?
Yes.
Okay, we'll break now till 2. Thank you.
All right.
Score is to down till 3 p.m.